Thank you, Senator Griff, for your contribution. Senator Singh.
Thank you. I rise to speak on the Privacy Amendment's Notifiable Data Breaches Bill with a sense of relief, but also with a sense of déjà vu. As the Senate would recall, I introduced a private senator's bill of the very same intent in 2014, the Privacy Amendment Privacy Alerts Bill 2014, a bill that was thwarted by this government. So I would like to take a step back and actually highlight the history of this important issue, and it is an incredibly important issue. After extensive consultation, Labor introduced legislation in government in 2013 to implement mandatory data breaches alerts. And this bill was passed on the 6th of June 2013 by the House of Representatives with bipartisan support. It was introduced into the Senate and was referred on the 18th of June 2013 to the Legal and Constitutional Affairs Legislation Committee for inquiry. The committee reported on the 24th of June 2013, its sole recommendation being that the Senate pass this bill. The bill then lapsed on prorogation of the 43rd Parliament, so I reintroduced an almost identical bill, the Privacy Alerts Bill, as a private senator's bill in 2014, a bill to make it compulsory for corporations and governments to notify people if their privacy is breached and personal details are released without authorisation. Now, at the time, the coalition senators in this place filibustered extensively to ensure this piece of legislation did not pass. Despite that record that they had of bipartisan support, time and time again they came into this chamber and filibustered on this important legislation, this legislation which today we have similarly in this place. So it is now clear why it was not the piece of legislation that was the issue, but it was that Labor had introduced it. Clear playing politics on such an important issue as people's privacy and their privacy being breached. Labor has always been committed to mandatory data breach notification provisions and, of course, therefore supports the government finally enacting these protections. Unlike the coalition senators, we won't play politics with people's lives, with their privacy and the breach thereof. We believe, Labor believes, that Australians should be told when there has been a breach of their privacy. And at this very moment in time, and since 2013 when Labor first introduced this legislation, there is nothing in place to notify someone if their data has been breached, if their privacy has been breached in that sense. So it is time, very much so, that companies, corporations and government agencies who are required to protect Australians' personal data should be also having the complementary duty to tell a customer when their personal data has been the subject of unauthorised public release. Businesses that already implement good privacy practices and comply with the current voluntary guide from the Office of the Australian Information Commissioner will have little difficulty in transitioning to this new scheme, because they already are showing an obligation towards their customers. But the risk of data breaches and the seriousness of their consequences has grown as new technology has allowed government and the private sector to collect more and more personal information about Australians. A consumer should have the right to know if their personal information has been compromised, or if their bank or their telecommunications provider has lax security standards. Consumers need to have the power to change their passwords, improve their security settings online, cancel their credit cards, or completely change providers such as banks or telecommunications companies if they need to do so. But how can they do any of that when at the moment they don't even know that their data has been released? That is what this legislation is all about. That is what makes this legislation so important. And that is why Labor introduced it in 2013, and I similarly introduced it in 2014, yet it did not pass this place because of those coalition senators filibustering and not having it pass, because they didn't want Labor to have that win of being on the side that introduced it, and that is shameful. So let's look at some of the breaches that there have been in recent years. And there have been a number, because as I said, we are living more and more in an increasing digital world. More and more data and personal information is being collected from about Australian families, and this bill, of course, puts in place some kind of compulsory notification regime in order to strengthen those protections around that information and build on the privacy regime that I talked about that Labor implemented when in government. Some of those highly publicised data breaches have included sensitive and very personal details of customers, such as the 15,775 Telstra customers that were affected by a breach which made their names, telephone numbers and home and business addresses accessible through a global Google search. And that was only one example of several Telstra privacy breaches, in fact. There was, of course, that shocking 1 billion Yahoo customers that have been affected by hacks. Private information, again, including names, email addresses, telephone numbers, dates of birth, and some passwords were actually accessed. And it took 2 years for that news of the breach to be made public. 2 years before those 1 billion customers had any understanding or not of their data being breached. Aussie Travel Cover, one of Australia's largest insurance companies' computer systems, was hacked. Around 750,000 records of personal details were stolen. Those included names, phone numbers, email addresses, travel dates and how much their policies costed. Addresses and partial credit card details were stolen, and that company opted not to tell customers about the hacking, completely left them in the dark. Well, this is why this legislation is so important, and this is why Labor has been pushing it for so many years. Catch of the day, in which personal information and credit card numbers were stolen. It took 3 years for the news of the hack of that one to be made public. 3 years in which customers, again, were unaware of their personal details not being secure. Catch of the day has not released the number of consumers that were affected by this breach, but Australian consumers reported fraudulent activity on their cards shortly after the breach. So, go figure. The poor old consumer had to figure it out for themselves. These breaches have also affected the government sector. In 2014, the personal details of almost 10,000 asylum seekers were accidentally published on the Department of Immigration and Border Protection's website. The details included full names, gender, citizenship, date of birth, period of immigration detention, location, boat arrival details and reasons why the individual was deemed to be unlawful. Absolutely appalling. McPhee Lab's threat report for August 2015, which reviewed changes in cyber threats and cybersecurity from 2010 to 2015, states that there has been a monumental increase in the number of major data breaches and in the volume of records stolen. I mean, there couldn't be any more clear evidence to outline why this legislation has been so important to get through this place. Yet it is now 2017, some 4 years on since Labor first introduced this bill, or a bill of similar intent. And, finally the government is going to act on it. It should not have had to take this long. And in fact, if it hadn't have taken this long, there are a number of data breaches that, could have been managed a lot better than they were, leaving consumers in the dark. So, nor are data breaches a concern just for individuals. although I do think first and foremost the individual is of utmost concern. The security of personal data is of commercial importance to Australian companies. Data breaches are simply bad for business and can be incredibly costly. Companies stand to lose not just time and money rectifying a data breach, but also, of course, their reputation. And in the modern information economy, the trust of consumers in a company's privacy compliance is an incredibly important part of that company's goodwill. It is clearly in people's minds what happened when Telstra had that massive data breach of those thousands and thousands of people's information. It is clearly in people's mind what happened to those 1 billion Yahoo customers and whether or not those Yahoo customers wanted to stay with Yahoo after that time. And when Kmart and David Jones experienced data breaches, both notified their affected customers. Now, that is good corporate policy. That is showing goodwill in a company's attitude towards their consumers. That is the kinds of positive steps that some corporations have made and goes in contrast to those that simply hid it away, the ones that I highlighted earlier. But a mandatory data breach notification scheme is the most basic of privacy protections, allowing consumers to take action such as cancelling credit cards when their data has been hacked. It is that simple, and yet it has taken this long for this parliament to act on it because of those coalition senators. Now, while it's customary for many banks and government departments, retailers and telecommunications providers to notify customers of breaches, it is simply not compulsory. They don't have to do it. So in practice, this means that victims of serious breaches are simply not aware that their data has been corrupted. This bill before us today, which amends the Privacy Act of 1988 to introduce mandatory data breach notification provisions for agencies, organisations and certain other entities that are regulated by the Privacy Act, is so important because it requires those agencies and organisations regulated by the Privacy Act to provide notice to the Australian Information Commissioner, first and foremost to the Australian Information Commissioner, and then affected individuals of eligible data breach. At the moment, that does not exist. And I've highlighted all the examples of which some companies will nevertheless tell consumers and customers, and others simply will hide away and not do so. This means a data breach arises where there has been unauthorised access to or unauthorised disclosure of personal information about one or more individuals, or where such information is lost in circumstances that are likely to give rise to unauthorised access or unauthorised disclosure. The bill will introduce a new consumer privacy protection for Australians that will keep their personal information more secure in this digital age, and it will also encourage agencies and private sector organisations to improve their data security practices, an important general step that they should be taking anyway. If an entity suspects that an eligible data breach has occurred, they must undertake an assessment into the relevant circumstances, and in the event of an actual data breach, an entity is required to notify the Information Commissioner and affected individuals as soon as possible or as soon as practicable, after the entity is aware that there is reasonable grounds to believe that there has been an eligible data breach. To give rise to an eligible data breach, the reasonable person would need to be satisfied that the risk of serious harm occurring is likely, that is, more probable than not. And in deciding whether this is the case, entities are required to have regard to a list of relevant matters that I understand are included in this bill. Failure to comply with an obligation included in the bill will be deemed to be an interference with the privacy of an individual for the purposes of the Privacy Act. and that will engage the Commissioner's existing powers to investigate, make determinations and provide remedies in relation to non-compliance with the Privacy Bill. So despite the delay tactics of the Coalition, this important issue has remained on the agenda. There has been a number of reports about it. I know that the Australian Financial Review have reported a number of times about this issue, and also the Parliamentary Joint Committee on Intelligence and Security recommended in its report on the mandatory data legislation in 2015 that if the legislation went forward, it was vital that data breach notification legislation be introduced as well. The Coalition government, I understand, was committed to introducing mandatory data breach notification provisions by the end of 2015. It is now 2017. It has taken the government more than 3 years to bring itself to introduce this legislation that it voted in favour of back when Labor was in government in 2013. If the government had introduced that legislation 3 years ago, thousands of customers would have been promptly notified that their data was breached. If they had put aside their partisan antics, we could have had privacy alerts legislation when I introduced the bill in this place in 2014. So the government has finally caught up. Pleased to see, Mr Acting Deputy President, the government has finally caught up with Labor's proposed legislation for mandatory notification of consumers when their data has been breached. I am very relieved indeed that the government is finally getting on to honouring their commitment, but the impact of their delay tactics have had on the people of Australia should not be underestimated. That is why we support this bill, Labor supports this bill, but notes very clearly that it is long overdue.
Thank you, Senator Singh.